Welcome back. By most indications, this was the most heavily litigated presidential election in history. A significant amount of that litigation occurred after Election Day. While the individual cases have almost uniformly gone against the current president, the merits of those cases deserve a deeper dive for clues about how courts may adjudicate election law disputes in the future. Nate Persley is professor of law at Stanford Law School and co-director of the Healthy Elections Project, and he will lead this conversation. Nate, thank you for joining us today. And please bring this very long day of panels home.
Thank you. Well, you know the old Shakespearean quote, first kill all the lawyers. I think it's second, put them at the end of a full day of Zoom meetings and see if 6 lawyers in 45 minutes can cover the multiplicity of election-related litigation. So there's been an incredible conference. Kudos to all the folks at BPC who put this together. And we've got an incredible panel to take us home here. We have Lisa Mannheim from the University of Washington, Ben Ginsberg, formerly, one of the nation's most accomplished election litigators, most recently of Jones Day. Soon will be teaching with me at Stanford next term. That is now his claim to fame, as well as having been the co-chair of the Presidential Commission on Election Administration. Rick Hasson of UC Irvine and the election law blog, as well as all other kinds of public goods in this field. Ned Foley from Ohio State University, the Moritz College of Law at Ohio State University and election law at Moritz, and Guy Uriel Charles from Duke University. So we've got a lot to cover, in part because this election season has been so fruitful from the standpoint of litigation. And so I want to jump right in. Lisa, let me start with you. If I had asked you before this election, or before November 3rd, that we would be in a post-election period with roughly 60 cases being litigated, what would your prediction have been as to, say, what the sort of state of the controversy would be, the likely split in those cases? People like Rick Hasson were writing books like Election Meltdown. That sounds like a prescription for a meltdown, but it seems that in many ways we averted it. So talk a little bit about this post-election period and what we might have thought would have happened if we were in this situation.
Yeah, thanks. And thanks so much to the center for putting on such a terrific panel today. It's really been really been great. So in terms of, if you see dozens of cases being filed by a given candidate after an election, I think there's a good chance that those cases are going to come out in a pretty lopsided manner. And the reason why is because with that sort of filing strategy, there's a good chance that there's actually nothing wrong with the election. Rather there's something wrong with the litigation strategy. When it comes to the role that the courts play in an election after Election Day, it's really quite limited. There's basically 2 situations where it's appropriate for a court to sort of come in and say something about an election outcome. In the first set of cases, it's where the margin in the election is so small that that election potentially will turn on relatively minor technical questions of election law. And in that circumstance, it can make sense for a court to come in and then resolve those questions that maybe otherwise didn't need to be answered. The thing is, when it comes to those really close elections, they just don't happen that often. We have thousands of elections that take place every election cycle. Maybe a small handful are going to be that close. The second category where it can make sense for a court to come in is when there's been some sort of systemic breakdown of the system that the election officials themselves can't resolve. And it's a testament to the strength of our election officials, frankly, that these sorts of situations also don't happen very often. So if you have a situation where you have a given candidate who's either bringing or supporting dozens of lawsuits after an election, it is not the case that we have elections and we have a system of court involvement that would really ever justify that sort of approach. This then maybe leads to the question, what is the litigation strategy that we've been seeing here if it's not one where the candidate has been trying to use the courts in the way the courts are designed? And to that end, I don't have insider knowledge, so I don't know for sure. But there seems to be at least sort of three strategies behind the president's post-election litigation strategy. All of them are quite troubling. The first one goes to the idea that maybe the courts or the judges can be enlisted in not sort of following the law and resolving these sorts of disputes, but instead that the judges can be convinced to essentially just vote for their preferred candidate. Obviously, this is not an appropriate use of the courts, and we have not seen the courts be willing to go down this line, which is in conflict with fundamental rule of law principles, obviously. The second sort of strategy that we possibly have been seeing since Election Day relates to the idea of sort of flooding the courts with lawsuits, flooding the courts with filings. This is something that lawyers have seen before, right? This is nothing new. It's sort of a strategy of litigation nuisance that can kind of overcome defendants, overcome the capacity of the courts, with the idea that maybe that will somehow break down the system in a way that will benefit the litigant. Again, this is not an appropriate use of the courts, and actually we have rules that prevent this. Finally, the third possible strategy here, I feel in some ways is the most troubling, and that seems to be that there may have been the idea that disinformation can somehow be amplified by sort of enlisting the courts in that process. There's sort of this idea that if you bring a lawsuit, it makes allegations, however wild, it makes them feel more official, more urgent, more legitimate. And again, this is not an appropriate use of the court systems. So going forward, we have a lot of stuff that we need to look at when it comes to this election. One of the things we're going to have to look at is how to strengthen the courts going forward so they can withstand this sort of employment, which is really not appropriate, frankly.
Ben, let me just turn to you on sort of situating this election in the sort of long history of election law cases that you've been a part of. Most notably Bush versus Gore, of course, but you've been doing recounts since, the bloody 8th Congressional District, now what, 40 years ago almost. And so this was a unique period, no doubt, what we saw after the election. Give us a sense of what you saw and how you would contextualize it given the kind of sweep of election law.
Well, Nate, and first, thanks to BPC for putting this on. It really has been a great day, and it's terrific to be with my fellow panelists as the only non-law professor here. So this election was unique for a lot of reasons. The pandemic obviously brought up a whole host of issues. But what was really unique about this was Donald Trump and the way he basically argued his case even before there was a case that he had to argue. So this was the first time where we've been involved in an election where a candidate, let alone a sitting president, has said from way back when that the elections were fraudulent and the outcomes were rigged. And so that put a unique set of pressures, I think, on this election that would have had a unique set of pressures anyways because of the pandemic. The other thing to remember about this election is that it wasn't really close. Yeah, it was kind of narrow, but 4 years ago when Donald Trump got the same number of electoral votes, he said it was a landslide. And that's the amount that he lost by this time. So this was not a close election in the Bush versus Gore sense. And this was the first time that we've ever had a president, a candidate, let alone a president, say at one point, let's stop counting the votes before they were all counted. That was categorically different from Florida. And so I think what you saw in this election was the breakdown of the usual arguments of the parties. Republicans see fraud every time they turn around. They put in a number of laws, mostly because they were so successful in state elections earlier in this decade. And the Democrats said this was voter suppression, and then everyone went to town in litigation. And that was the pre-election period. In the post-election period, again, it was a barrage of lawsuits. The central allegation that might have made the Trump case work was, number one, a much closer election, and number two, a scintilla of evidence for the underlying notion that this was somehow fraudulent. I do think that certainly state and local election officials, all the folks who were on earlier panels, showed that the system worked. In point of fact, the courts worked. And that judicial nominees of both parties, including the conservatives who Donald Trump, in Lisa's accounting, kind of relied on to give him favorable victories, really did uphold the rule of law, but that they were put in that pressure made this election unique.
Let me continue with that with Rick Hasson. You wrote a book, Election Meltdown, last year, published right before the pandemic hit, I think, right? And if anything, we probably thought that the likelihood of a meltdown even increased, right, with the additional stress that the pandemic posed. Part of the possibility for meltdown would have been, incredible polarization among the judges that we didn't see, right? And so I want, if you could reflect a little bit on, how melted down did the system get this time? And are you surprised by the sort of unanimous rejection and the fact that the courts held strong, really, to prevent any of these lawsuits from going anywhere?
Thanks for that. And let me thank BPC not only for this panel and today, but for the work it's done throughout the election season. And I think that's something that is a good place to start with this idea that we didn't have a meltdown, not just because we got lucky, but because many people worked extremely hard, starting with the election administrators who made this election successful despite the incredible challenges that came up because of the pandemic. And, if you look at the pre-election litigation, the litigation over changes that were made because of COVID or changes that were not made despite of COVID, it seemed to fit much more of the pattern that Ben described, where eventually, as these cases made their way up the food chain and to the Supreme Court, we did see the usual partisan divide between the justices and the judges, with the more liberal judges putting a thumb on the scale in favor of voting rights, and the more conservative judges putting a thumb on the scale in favor of deference to states to set the rules for how elections should be run. But I think you're exactly right, Nate, that in the post-election period, what we saw is that the Trump campaign went too far, that it actually brought together the conservative and liberal judges and justices in a way that I think showed that the courts did hold. And it was because of the kinds of arguments that were being raised that were so beyond the pale. And I think it really culminated or crescendoed in the Texas filing, where you saw one state advancing completely ridiculous, both legal theories that one state could tell another state how to choose the presidential electors, and factual claims about voter fraud that were completely discredited. That really went so beyond the pale. And, just this morning, a brief was filed, a reply brief in the Supreme Court in the case involving the 10,000 or so ballots that came in the 3 days after Election Day that the state Supreme Court in Pennsylvania said should be counted, and the US Supreme Court is still deciding about. It won't make a difference in the outcome of the election. But on that brief, you had Mike Carvin, Noel Francisco, among others. And so I think the fact that those names, the leading, you didn't see a Paul Clement, you didn't see a Mike Carvin, you didn't see the leading Republican election lawyers come into these suits. So I think it does show that this was a very different kind of election and a very different kind of election challenge. And we've never seen a Democratic or Republican president so push the system. And we got lucky in the end, because I think if we were down to a single state where it was close enough, the pressure would have been kind of insurmountable for a state legislature to appoint electors, or for state judges or a governor or someone to interfere. We came much too close for comfort. And it does suggest that, as we saw throughout much of the Trump presidency, so much depended on norms rather than on law in terms of how we structure our rules for politics. And maybe that means going forward that we need more law and fewer norms in order to cabin bad behavior in the future.
One thing I'll add, so at the Healthy Elections Project, Stanford MIT Healthy Elections Project that Charles Stewart and I ran, we developed a litigation tracker. And while we weren't sure how much post-election litigation there would be, the team led by Zahava Levine, who has been working on that, has not had a day's sleep since then. And so those who are interested, I put it at the memo that they've done on the post-election litigation at the top of my Twitter feed @Personally, if you want to check it out and look at all the other resources at healthyelections.org. I want to follow on what Rick was saying, Ned, and ask a little bit in some ways about the education lesson that we all got as to the sort of federal superstructure of presidential election law. And you are really the leading scholar on this from your book Ballot Battles, as well as the many articles you've written on this. Let me just start with the question that you no doubt are getting when you go on TV quite a bit these days, which is it over yet? Are you sure it's over? Are we, and if it's not over, what remains to be done? And can you walk us through it a little bit?
Yes. Well, and again, let me add my thanks to BPC for a great day and for all the work it does. And for doing it on this day, because yes, I think today we can in fact say it's over. And that's not just because the Electoral College met yesterday, but I think we shouldn't underestimate the significance of Senator McConnell's statement today. You know, he announced after the media called the election that the media doesn't get to decide the winner, and he's accurate about that as a matter of law. And he said that when the process reached its finality and conclusion, he would have another statement to make. And he made that statement today, and it was a congratulatory statement of both the president-elect and the vice president-elect. And I think that itself provides some important measure of closure. You know, I don't think there was ever going to be any doubt as to what the result of the January 6th joint session of Congress, which exists under the 12th Amendment to receive the electoral votes that happened yesterday and officially count them, was going to be. And that was going to be true regardless of what Senator McConnell said, because of just doing some math in the Senate and understanding these arcane rules of the Electoral Count Act from 1887, which is so bizarre, but nonetheless has, you know, some verbiage to parse. But
some have made a career out of that, or a small career lately.
Well, I mean, but you know, I've said, you know, I've spent well over a decade trying to understand the darn law, and I still don't understand it. And I try not to blame myself for that. I sort of think it's the law's fault, not mine. Maybe it's my fault. But anyway, I want to thank Senator McConnell because he makes it so much easier to understand how this will actually go on January 6th now, because it's partly a political response as well as a legal one. And just the dynamics of it are going to be, you know, so much different with him as the leader of his party in the Senate, you know, fully behind the declaration of President-elect Biden's victory. All of that leads me to have a plea that maybe we could have the leadership in Congress, as well as the new administration and Congress, really work together to reform the Electoral Count Act from 1887. Because to Rick Hassan's point, we really did come very, very close this time. Scarily close in my judgment, given that it, you know, as Ben said, it wasn't that really a close election, and there was so much contestation. So this really could have gotten very, very ugly under the congressional procedures and the 12th Amendment, and it won't. I mean, there may be a little bit of theater on January 6th, but I'm not even sure the theater is going to qualify as being drama, thank goodness. But it should be a lesson to us that this is a very weak and fragile statute that puts the country in a very dangerous place, because the one thing that we need in a genuine disputed election, when the dispute reaches Congress, because it is a form of litigation, it's just not litigation in a court, it's now litigating the outcome in Congress. And the conversation, even over the last 24, 48 hours from Stephen Miller and these rival slates, they want to relitigate the result. There's going to be a hearing in the Senate tomorrow to try to think about evidence. You know, all of this is based, in my judgment, on a misunderstanding of the limited role that Congress has under the 12th Amendment. But the most important fact is that there's ambiguity here, and uncertainty about what the role is. And so we really need Congress on a bipartisan basis to come in and clarify what the procedures really are if and when a presidential election does get litigated to the point that the litigation reaches Congress under the 12th Amendment in a genuine way. So I hope we don't say, thank God we got past this one and we don't have to worry about this for another 4 years. I think the time is right now to realize just how close we came to something really bad and use the moment to say, let's fix this statute for the future.
Just so I understand, though, what you're saying, what else would you change about the Electoral Count Act? I mean, this is a kind of long buffet of various provisions from, part of the question of, the role of the state legislatures, role of the state of the governors, right, and certification. Obviously the deadlines and the safe harbor provision, right? You've talked a bit about, Marco Rubio had a bill that would have changed those dates. What else might you change in the current structure of the Electoral Count Act to try to make things a little bit better next time?
So quickly, first, I would just hold some hearings, some bipartisan hearings, just to have a conversation about this. Because again, I think there's a fundamental misunderstanding about what the Electoral Count Act does and what the 12th Amendment does. I mean, this goes to the point where you have members of Congress saying that they want to consider whether there was or was not evidence of fraud in Georgia and all these states. I mean, I don't believe there was evidence of fraud. I think all of this was baseless. As Ben said, there wasn't evidence. But jurisdictionally, I don't think Congress has any power to ask the question whether there was fraud or not. I quote Justice Joseph Bradley from the Supreme Court, who sat on the commission for the Hayes-Tilden dispute. And he said, quote, "It is the business and jurisdiction of the state to prevent frauds from being perpetrated in the appointment of its electors, and it is not the business or jurisdiction of Congress," close quote. Well, that's one understanding of a very limited role that Congress has under the Electoral Count Act. All Congress is supposed to do is ask itself, are we receiving the electoral votes from the state that the state wants to send to us, pursuant to authoritative institutions within the state having appointed electors? Whether they did so correctly or incorrectly under state law is irrelevant. It's just, is it the entity that had jurisdiction to appoint electors sending us their electors? If that's the correct understanding, and that was the understanding on which Hayes-Tilden was decided, it is absolutely improper for any member of Congress to be asking itself whether there was fraud in Georgia or not. That was for Georgia to decide, right or wrong. It decided, it's over. That's what finality means. But there's disagreement among our community of law professors on whether or not this is the right understanding of the Electoral Count Act or the wrong understanding. So I think we just need to know what this law is supposed to do. Hearings can help. And then I think we can decide whether we want to go big or go small in terms of reform. Going small would simply mean to put in 21st century language whatever the darn thing is supposed to mean, so at least we can understand it without trying to make new policy choices. Going bigger would be to say, okay, let's rethink as a matter of policy for the 21st century what we want this kind of set of rules to be.
Great, thanks. And so, Guy, one of the features of having a post-election period where you've got 60 cases, it seems like, every type of judge happened to be involved in one way or another. We had state courts, we had federal courts, right? We had, if people were paying attention, in Pennsylvania, we had something even called the King's Bench petition, which made me think they would start donning their wigs and the like there. So there are obviously different rules, and we frequently, when we all of us remark on the structure of the American electoral system, it's not only 50 different systems, it's 10,000 different systems in some ways, given the decentralization. But from the standpoint of, thinking about the litigation this time, the role, the forums that were exploited by different litigants, what are your thoughts on what the litigation this time tells us about election litigation writ large, and division of state and federal roles and the like? I think you've got to unmute yourself.
Thank you, Nate, and thank you to the BPC. So you also pointing to one of what I view as one of the weaknesses of the system. So lawyers often worry about forum shopping and a dual federal system, as well as arbitrage in a dual federal system where, you know, you're manipulating, it's not about the substance of the merits of the case, but really trying to get either a better judge or a better forum in order to get a favorable outcome. And this is related to where Lisa started us off at the very beginning, to the extent that post-election litigation is as much political theater and as much related to politics and framing as it is, if at all, about the merits of addressing underlying substantive issues, right? So to the extent that it's much more about theater and politics and much less so about redressing substantive legal issues, then the worries that forum shopping becomes a significant worry. The ability of lawyers to be able to look around the country and to be able to say, okay, we're going to file a lawsuit in Arizona. Well, why Arizona? Well, that's the place where we think we might be able to get something because we need it. We need a political win, and we're going to file it in front of this and this particular court because the hope is that you'll get a draw of a judge that will make it more likely to win. Now, what was remarkable about this cycle is, for the most part, forum shopping and arbitrage, and it was tried over and over and over and over again, and yielded nothing, right? So that's remarkable. But in some senses, that tells us a lot more about how extreme the challenges were. This is something that Rick also pointed to, right? It tells you about the absolute lack of merits of the cases. Now, you take a context in which there is some merit to the challenges, then the strategy really then comes into play, to the extent that more than one state is in play, to the extent that then you can go to state court as opposed to federal court. And part of what's interesting, at least to me, is the fact that the states use the same rules for these high stake elections, right, presidential elections, as is used for any run-of-the-mill type of litigation. And we saw in this process, with many of us lawyers trying to game out and think about how this particular litigation might play in this particular court, or how it might play in front of this federal court. And of course, we also had litigation, the attempted litigation to file an original lawsuit in front of the Supreme Court itself. And it does raise the question, to the extent to which we ought to treat presidential litigation that arises out of a presidential election as a separate category, as a different thing, and maybe even the presidential election as a separate category, as a separate thing, particularly with respect to state election laws, right? Because in a close election, where more than one state might be in play, and the opportunity for forum shopping and arbitrage, which then introduces some randomness into the outcome because of the favorability of the judge or the favorability of the forum, then we might be in a very different place than we are today. So today, it didn't, right, this past cycle, nothing panned out, though we saw it repeated over and over, repeated lawsuits in multiple states, change the plaintiffs, change sometimes not even change the facts, and simply file in a different court, and even under the same lawsuit in a different state. So it amounted to nothing, precisely because the election was not that close, precisely because it was very well run, precisely because the claims were not at all strong, and that's putting it mildly. But in a different context, then the outcomes might in fact be very different, and we might get the types of prolonged litigation that we worry about. And so some type of reform in this area might be necessary.
Can you talk a little bit about the desired reforms? I mean, whether it's with respect to that, I should note that Ned also led the American Law Institute work on some of these election recount issues and the like, and contesting elections. And that had some suggestions in there, either with respect to what you just specifically were talking about, such as the litigation, reforming of the litigation for presidential elections, or more generally, lessons taken from this election, I'll ask every panelist this question of what reforms you think are needed and that could be helpful in avoiding a potential meltdown.
Sure. I like the way that Ned started thinking about this. So part of it depends on whether we simply want tweaks or whether we're in a position to rethink the structure altogether. If we're ever in a position where we're actually doing some rethinking, my suggested reform will be to treat litigation from a presidential election as a special thing that deserves its own special court. That would be my preference, would be to think about, and one could do it at the state level if one wants to, and you could create some model frameworks for that, and maybe could be piloted in some states. But that would be my preferred sort of big thing, because in fact, what we saw in this process, in the attempt to treat this litigation as a run-of-the-mill, go ahead and file something, file as much as you can, hope something sticks, really does raise a deep problem. I see some commission from Nate, maybe even a commission. I think from there's some people with great experience on here with commissions and with great suggestions from the commission. So yeah, those are possibilities. So if we're going to go big, that's the approach that I would suggest.
Lisa, let me ask you that same question. Either thinking about it from the standpoint of a lawyer and thinking about changes in the rules that would affect litigation, bring certainty and the like, or more generally on thinking about election administration and the bullets that were dodged in this election and how we can make sure that they don't hit the heart next time.
Sure. Well, I guess I'd say two things. So first, Nate and others, Ned and others, as you say, through ALI have come up with a number of different suggestions regarding reforms that states can take to adopt more specific election codes, more specific rules for the resolution of election contests, not only in the presidential context, but also in other races. And particularly when the courts are getting this sort of pressure, there can be a value in just having rules set, regardless, frankly, of what exactly they say. In that situation, you don't have two reasonable outcomes and then potentially a fight between judges who very well may be elected through partisan elections. Instead, you have a clear rule on the books and the judges can frankly point to it and say, look, my hands are tied. And to the extent that we've seen rules like that, so for example, even at the US Supreme Court, with the Texas litigation, there are just clear rules that prevented that lawsuit from going forward. And so what we can get out of the US Supreme Court is a short, essentially unanimous opinion saying, no, this isn't appropriate for us to look at. So on one level, just having more rules might be helpful at this point in time. The second thing I would say is that while I'm very sympathetic to having different procedures in the presidential context, and one of the reasons for that is because we have a different timeline there. So you could have an election contest theoretically last 6 months, like we had in the Franken-Coleman case, and you can still have eventually the election resolved. If you wait too long with the presidential contest, then it's done. It's the person's already in office. I am concerned about one centralized body resolving sort of all these contests. And the reason why is because that's potentially subject to capture. And frankly, given how aggressive the president has been prior to the election and after the election, I am more grateful for the lack of a strong centralized agency at the federal level than I was before this election cycle, because I would be very worried about what an aggressive president or other might do if there was just a focal point to focus that sort of energy.
So Ben, you've written in the Washington Post recently on potential reforms or at least ways of thinking about it. Do you want to sort of explain what your position is on this? What did we learn in this election about the need for reforms, and which particular reforms do you think?
Well, a couple of points. First of all, and this is based on the experience of the 2000 election, that leaves some residue with the person who won it. And the notion that President-elect Biden is going to want the Congress to go and delve into cures for this election is, I think, misplaced. I mean, I think his desire is going to be to move forward and deal with all the myriad of problems in issues other than elections. And there will not be a desire to revisit it for purposes of fixing the Electoral Count Act or for much of anything else. So that's why Nate's idea of a commission actually, I think, has a great deal of saliency to it. The second, in looking at what happened in this election, is a lot of the laws that we're talking about go off on the fraud suppression dichotomy, what Rick accurately described as suppression or upholding state legislative judgments. And there were some surprises in all of this. First of all, a lot of the Republican positions on what to do with laws is based on this haunting fear that if everybody gets to vote, they're not going to vote for Republicans. And so high turnout elections are bad. Well, this was a very high turnout election. And while the presidential race was lost by Republicans, they did quite well down ballot, and especially really down ballot in legislative races in the states. And so Republicans can take away from this. They don't need to fear high turnout elections. And conversely, Democrats did quite well in states with some of the strictest voter ID laws in the country, Arizona, Wisconsin, and Georgia. And so the idea that voter ID laws are bad can get re-examined. And interestingly enough, I would commend to everyone the 9-tweet thread that Arizona Governor Doug Ducey did about the laws in his state that enabled him to tell President Trump that President Trump was wrong and he was not going to try and mess around with the results. But that included things like voter ID and a lot of poll watchers and the way they do signature verification on ballots. So a lot of the laws that Republicans love to put in did not prove needed in the turnout realm. And Democrats could do some rethinking on the broad definition of voter suppression. That would get us to a better place at looking at the changes in individual state recount and contest laws, because I certainly agree with Lisa that a national recount law would be a little bit of a frightening thing.
Well, let me ask, given for both Ben and Rick Hassan, whether, given the incredible polarization in people's views about the performance of this election, how capable are we actually to address that, right? If one of the things that we need to target is the fact that there's low level of confidence in the democracy, and problems that people perceived, some of which are not connected, as you were saying, Ben, to real problems on the ground. Are we boxed in? Have we crossed a Rubicon right now that it's going to be very difficult to come back from, as to broad-based lack of confidence in the system? And is there anything we can do about it?
Well, in my mind, the way to deal with the Republican belief, the belief in so many Republicans that somehow the elections are rigged and fraud exists, is that I actually hope that either the individual states involved in this, or maybe this is a congressional function, actually provide a forum. I mean, what recounts and contests are put up or shut up events. And what's true of Trump in this election, which has been so bad, is he has neither been able to put up, and God knows he hasn't shut up. So that's what the problem has been. And I believe that you need to somehow release the pressure of this unfounded belief about fraud. And so give them a forum to actually try and bring forth the evidence. I think they're going to fail on that, just like the commission that Trump set up in 2017 failed. But I think that's the way that you will have to explode the myth of voter fraud, is to actually provide the forum and see if they can prove it, which they can.
Rick Hassan, you've been chronicling since Bush versus Gore, I think, in a series of articles, or at least in a series of graphs that I know of, looking at the election litigation over time. And we probably passed some kind of milestone in this election. I'm eager to hear from you on that. But given this, the level of controversy, the partisan polarization in distrust, do you see a way out in terms of broad-based reform or even a compromise that would be possible in order to address some of this lack of confidence?
So I think the question is whether the Trumpist moment fades or grows when this election is over. So I think I disagree with Ben. The first thing I disagree with that he said all day was the last thing he said, which is that we need to give a forum. There's been ample forums. There have been state and federal lawsuits where evidence could be put in about fraud, and there really is nothing there. But the amount of fealty that some Republicans have felt they needed to show to this president, the 17 attorneys general that signed on to the ridiculous Texas case and the 126 Republican members of Congress makes me think that this is going to last for a long time. And I think as desperate as we're going to be for a need for reform, and I would say the number one thing would be to remove discretion at all the points where we don't need discretion. Once the Electoral College vote numbers are known, we shouldn't have to know who the Wayne County canvassing board members are or worry about faithless electors. It should be kind of automatic from that point, or about what the definition of failed election means in the Electoral Count Act. So I think there's so much that could be done to alleviate discretion that would make things better, but this doesn't seem to me to be the political moment where it's going to happen, so long as Trumpism has a grip on the Republican Party, at least on the federal level. I think on the state level, a lot more can happen. And, I never thought I'd be saying that Brian Kemp is a voting rights hero, given the stuff I've written about him in the past, but it really did take a lot of heroism on the part of a number of Republican election administrators and elected officials to beat back this relentless assault on democracy that we saw from the president.
Guy, do you want to chime in here?
Yeah, one quick point. I think the Georgia runoffs are going to be extremely important here because if you are undermining belief in the system and it causes you to lose elections, then that presents a self-correcting mechanism in one version. You can't both tell people the system is corrupt, and you need to participate, right? You sort of have to make a choice. And so it depends on what happens there, because then the message the system is corrupt might need to be changed if it is important to get people to participate, so that way you can hold on to political power. So I think that's something important to keep one's eye on.
Yeah, well, it is an interesting question as to whether these signals about a corrupt electoral process are going to have a differential impact on turnout. I mean, this is an interesting test case that we'll be going through in Georgia. One thing that I worry about is that when people say, look, the accusations that the Trump campaign has made about the integrity of the election are going to be damaging to people's belief in democracy over the long term, how do we actually measure that? How would you identify an example where this has sort of reached a new low? And one thing I'll be looking for is, in the event the Democrats lose the Senate races closely in Georgia, how willing will they be to accept the outcome, right? If this language becomes just the way we start talking about election losses, will this actually be a bipartisan sort of approach that really those who lose elections are just going to be attacking the process? Ned, take us home here a little bit. Talk a little bit about what the litigation that we have witnessed says going forward, and the role of judges in some ways. We've talked about, or those of us who are in this field remark often about the Purcell principle, which has come up time and again which really is a doctrine of judicial restraint at its heart. Like, to what extent should the federal courts be upsetting the status quo in a given election after the rules are fixed? And sort of the way the different courts have been talking about that principle was important, particularly in the pre-election period. What are your thoughts on that?
Yeah, thanks. So what strikes me about this conversation, which I think is really helpful, is Guy and Lisa and others have made points about sort of jurisdiction, avoiding forum shopping. And I think Lisa's absolutely right that it's better to to rely on federalism and keep this at the level of the states. I think that's good to announce ahead of time, because people try to relitigate that or revisit that issue when it's to their partisan advantage right in the moment of the election. So the more we can get clarity on a jurisdictional point like that, the ahead of time, the better. But I also think that applies to timing rules as well as institutional rules. Like there's the who gets to decide these questions, and there's when do they get to decide them. And what struck me is so much of the litigation this year, both before November 3rd and since then, has actually been about timing. So there's been never as much debate, to my knowledge, about this doctrine of Purcell, about when is it proper to bring a lawsuit, as there was this time. And this was a judge-made principle that the Supreme Court came up with. It would be better, I think, to codify that in some way, shape, or form, so you weren't fighting over what's the proper application of it. We just know these are the rules about when you can bring the lawsuit. Likewise, related to that, after November 3rd, we had a lot of litigation over things called laches and estoppel and waiver, about whether it's too late to bring a lawsuit, should have been brought ahead of time. Again, a lot of that is judge-made law, which means it's squishy and open to manipulation. Maybe those are the kinds of things that could be codified so that we know in advance, what those timing rules really are.
I'll say one thing, and this is in response to some of the comments earlier about how close were we to an election meltdown. If you do the math, if 20,000 voters changed their minds in this election between Wisconsin, Arizona, and Georgia, we would have ended up with a tied electoral college vote. And even though what ended up happening, the number of states that were in play were different than we saw 4 years ago. Imagine what would have happened either if we were under the scenario that Rick originally described, which is that it was a Florida-like scenario where we would have ended up litigating it like in Bush versus Gore, or if we ended up throwing this to the House and we would have had yet another civics lesson on top of all the civics lessons that we were taught this time. Actually, Ben, let me just close with a question to you on this. Since you were obviously so embedded in Bush versus Gore and the 2000 election controversy, in a sense, what's different today from your experience then? What would have happened? Speaking more generally about election litigation and the like, but also what would have happened if we had almost the identical situation of Florida, but happening in this environment?
It would have been a lot more difficult and tenuous. I think we benefited greatly in 2000 from the fact there was no such thing as social media at the time, both in terms of looking at individual ballots and in terms of disinformation and information flow. And I think that would have been hugely different. I think one of the real differences between Florida and 2020 was the way equal protection played out. Equal protection in Florida was about similarly marked ballots being treated differently. There's nothing about some counties in Pennsylvania allowed cures for absentee ballot signature problems and others didn't. I mean, it was a very granular equal protection argument in Florida that was tremendously different. And of course, the greatest difference, I think, is that back in 2000, nobody had a Bush versus Gore to refer to. Mm-hmm. So there was no sort of, gee, we have to avoid this, gee, we have to do this. And the last thing I guess is the timing issues involved in it really provide the most difficult lessons. That in fact, Florida in 2000 was right up to the edge of not having a state with certified election results and able to produce a slate of electors. And you could see in this situation with all the litigation, how had it been a less than 1,000 vote margin in an outcome determinative state, that you really would have bumped into the Electoral College problems, which would have gotten into the Electoral Count Act total inability to understand. And that would have been difficult.
Well, thank you. Thank you, Ben. Thank you, Rick, Lisa, Guy, Ned. I think I thanked everyone there. And thank you, Matt, for putting this on. It was an incredible day of panels to talk about the election.
Well, thank you, Nate, for closing us out strong. I want to thank all of the panelists and moderators who joined us throughout the day. I know my team at the Bipartisan Policy Center was honored that you all made it work, and I know the audience appreciated your expert thoughts about the future of elections. As I noted at the beginning of the day, which is about 6 hours ago, you should all expect this to be the first step in BPC's work over the next 2 years of election reform. There's a lot of work to do following 2020 elections. Thank you to all the audience members who came and went throughout the day, and to the hardiest among you who stuck around for the entire live stream. Thank you also to my team at the Bipartisan Policy Center, Rachel Ori, Collier Fnekes, Alejandro Marquez, Michael Thorning, Carolyn Cooper, Owen Baskai, and Hannah So. Without all of them, you would not have had we would not have had such a smooth production. And with that, I close out the BPC webinar reflecting back on 2020 and the need for reform going forward. Thank you.